to welcome everyone on behalf of the Small Business Association of Michigan. My name is Lori Berman. I'm the Vice President of Membership and Development. Thank you for joining us today. A couple of housekeeping matters. Wanted to let you know that as a participant, you can put questions out there. We will answer your questions at the end of today's session. Appreciate you being a part of this webinar. This is a part of our regular series of resources that we offer to members. This webinar will be recorded. You'll be able to find it on our website in the resources section, along with recordings from other webinars that we've done throughout the last couple months. We do have 2 webinars coming up in February. We have one on emerging technology that's related to payment processing for your small business. That's February 14th. And on February 21st, you'll find a webinar on optimizing your sales channel for small business growth. So you can look for those on the SBAM website under upcoming events. And again, this one will be online if you wish to share it with others. You do need to be logged in to be a member to be able to see those. I'd like to introduce our panelists today for today's burning hot topic, so to speak. We have 2 panelists that are with us, and a special thanks to Mike Burns at ASE for helping to set this up. The American Society of Employers is one of our valued partners here at the Small Business Association of Michigan. They offer our basic and premium members HR services, HR handbooks, research services, and also a portal to ask your HR questions. So thank you to Mike, thank you to ASE for helping to set this up. And let me tell you a little bit about our 2 panelists today. So with me, we have Ellen Hopner. Ellen is a member with the Labor and Employment Practice Group at Clark Hill. Ellen represents employers in all aspects of employment law. She is an experienced litigator and regularly defends employees in state and federal lawsuits and administrative proceedings against discrimination, harassment, retaliatory discharge, and wage and hour claims. Ellen partners with employers on a wide spectrum of matters, from drafting employment agreements and policies to managing tricky leave of absence, accommodation, and disciplinary issues. Ellen is also sought after a corporate trainer, frequently presenting on matters involving EEO compliance, preventing harassment, discrimination, and retaliation in the workplace, and effective techniques for managing within the law. Welcome, Ellen. And our other panelist today is Kevin Mars. Kevin serves as Vice President at the American Society of Employers, ASE. In this role, he was responsible for overseeing ASE's Compensation and Benefits Survey Department. ASE conducts a variety of local and national benchmark surveys, providing data to thousands of organizations in Michigan. For 20 years, Kevin has conducted research and analysis on the total rewards practices and trends of Michigan's employers. Kevin is also responsible for conducting employee surveys for ASAE member organizations. Kevin conducts several ASE training programs, including wage and salary administration overview, conducting job analysis, and writing job descriptions and market pricing for results. So I thank you both for being here today as our panelists, and I look forward to this presentation. Folks, feel free to put questions out there, and we will address those as we go. So I will turn it over to Ellen and Kevin. Thank you so much.
Hi, everyone. Thank you so much for joining us, and thank you, Lori, for that wonderful introduction. And thank you, everyone, for joining us on this hot topic of recreational marijuana in the workplace and employer rights. I'm going to go ahead and dive in because I know we only have about an hour here, but please do feel free to ask questions, and we'll make sure that we try to get to those at the end. So a couple of things just to give you a little bit of a roadmap of what we're going to cover. We're going to talk a little bit about Proposal 1 and what it does and does not say. Practical considerations for employers. That's really going to be the meat of the presentation today, because a lot of this is less law and more practical advice and considerations, including written policies, drug testing procedures, accommodations in the workplace, non-discrimination, and drug-free workplace. Let's dive in. As I'm sure you all know by now, last November, Michigan voters approved Proposal 1 by a pretty large margin. We had tried our hands with medical marijuana, and then recreational marijuana passed fairly easily last November. In doing so, Michigan became the first state in the Midwest and the 10th state overall to legalize recreational marijuana. This is definitely a growing trend that we're seeing across the country. The initiative that authorized Proposal 1 is actually 4 pages long. I think a lot of folks don't realize that and think it was just the language that was on the ballot that was the full language of the act, so to speak. And it's actually fairly detailed. It's 4 pages, and if you just sort of Google Proposal 1 2018 for Michigan, it will come up if you have specific questions. The proposal became an act and became effective law last December, just in time for the holidays, on December 6, 2018. It legalizes under state law possession, use, cultivation of marijuana and marijuana products and industrial hemp by persons 21 years or older. It's going to be a little bit of a time before we see commercial sites setting up across the state. Under that 4-page proposal, the regulators have until December 2019 to determine the rules for retail stores. So it's expected that sometime near the end of this year, there will actually be an application process and that the state will start to process those. So you're not going to be seeing these pop up in your area in the immediate future, but certainly sometime over the next year or so, we'll start to see that being implemented on the commercial side. Remember that marijuana remains an illegal drug under federal law. So although it's legal under state law, it still remains a controlled substance under federal law. The U.S. attorneys for the Eastern District and Western District of Michigan, which are largely the ones responsible for enforcement of federal criminal laws here in the state, issued a joint statement shortly after passage of Proposal 1, essentially saying, listen, it's never really been our practice to go after and prosecute folks who are using or possessing small amounts of marijuana. We're not saying that we're never going to prosecute it, because if it's involved in another offense, or if there are large amounts of it at issue, certainly we will use the tools available to us. But we've never been going after sort of low-level offenders in this area, and we don't anticipate that changing. Governor Whitmer, for her part, has said that she intends to use the clemency powers to free at least some of the what are estimated to be thousands of people who are serving time in state prison for marijuana-related convictions. So we'll see. She's made that pronouncement. So far, no action has been taken. So stay tuned on what that really means. Okay, employer rights after Proposal 1. This could be a pretty short slide, in that I could have just said, your rights did not change after Proposal 1. There's nothing in Proposal 1 that specifically requires employers to do anything with respect to recreational marijuana. So the Act does not require employers to permit or accommodate marijuana at work. The Act does not prohibit employers from disciplining or terminating employees who violate a workplace drug policy. The Act does not prohibit you from terminating someone who was working under the influence of marijuana or tested positive for marijuana under your regular drug testing procedures. Also doesn't require you to permit someone to consume marijuana on your premises. So I think there's a little bit of a misconception about marijuana. Just because it went from being illegal to legal does not mean that it now has some sort of protected status, that now it's elevated into like a protected characteristic, so to speak. You can still take action against someone for using or testing positive or possessing marijuana at work. And one of the most important things for those of you who would be subject to it is the Act does not change in any way federal regulations such as the DOT regulations for commercial driver's license holders. So those regulations require specific drug testing policies and procedures, and those remain unchanged for CDL holders, and you would need to continue to comply with those under federal law. So that's the short answer of the legal overview with respect to Proposal 1. It really doesn't change employer rights and responsibilities at work. That said, I think the reason why many of you are here today is that recreational marijuana has created some complicated practical issues for employers, particularly around the issue of drug testing. So let's jump into those here. Let's start with written policies. So employers really need to go back through their handbook and look at their policies and see, well, one, is this what we do? Does this encompass our whole policy and practice? And do any changes need to be made? So the thing that we've been seeing most commonly is that many policies used to refer to illegal drugs or illegal substances. And while that's not untrue with respect to marijuana, because of course marijuana remains illegal under federal law, I think it can cause some confusion for employees who don't understand this nuance between federal law and state law, what's legal, what's illegal. And so we recommend that you clarify in your policy, either by removing the word illegal or defining what that means and specifically calling attention to the fact that it includes marijuana, despite it being legal under state law. In general, your written policies should focus on prohibiting employees from possessing drugs and alcohol in the workplace, testing positive for drugs and alcohol, and being impaired while working. The testing positive is really important because, again, with respect to marijuana, we're going to talk about this a little bit more when we get to drug testing, but people need to know that a positive drug test, even if the person didn't consume it at work, even if they're not under the influence, the employer has no way of knowing that. And so a positive drug test in and of itself could be a reason that an employee could be terminated. And I think it's important to call that out in the policy and make sure that employees know that. I think also it's important for employers to consider how strong of a stance they want to take on this issue. I've heard many employers say, listen, I don't want to lose good talent if I don't have to. And so are there areas or ways where I can be a little bit more flexible, not have a zero tolerance policy, perhaps a one strike policy or something that's a little bit more flexible when an otherwise good employee is not suspected of being under the influence at work, but still tests positive either because it's done post-accident or because it's done during a random drug test. Revisions to no smoking and employee conduct policies should also be considered. Sometimes there will be these sort of cross references to illegal drugs or a positive drug test. So you just want to make sure that that's all consistent. Another important thing is that employers should consider, whether to republicize their existing drug policies and remind employees of your rules and expectations. So this is something that both in December and even now, I think is really appropriate for employers to do, which is just to circulate a memo, and I've included some proposed language here, but certainly you can feel free to deviate from this depending on tone and your specific policies. But something that says, listen, we understand Proposal 1 was passed, but that doesn't change our drug policies, and we still prohibit you from using, possessing, being under the influence of drugs at work. And if you violate these policies, you may be subject to disciplinary action up to and including termination of your employment. Again, a positive drug test could result in termination. This is important to remind employees so that there's, clear expectations set for them with respect to this issue. I think these types of memos, I've seen them put on bulletin boards, circulated by email, go out with the paycheck, however you normally communicate with employees. This is really a good time to clarify, because although, again, the law itself didn't change a lot with respect to employer rights, but many employees don't understand that nuance. They don't understand why they can be terminated for something that's legal. So it's important to be clear with your employees about what your expectations are, and to communicate that, on the front end before an issue comes up. Drug testing. This is really the heart of the issue, I think, for a lot of employers. So the Act itself, again, does not prohibit an employer from conducting drug tests, and it doesn't prescribe any requirements around drug testing. Unfortunately, the practical problem is that, unlike alcohol, a positive drug test for marijuana does not tell the employer when the marijuana was consumed or whether the person is currently under the influence. So it's just going to give you a positive or negative. It's not going to tell you these key indicators. And I think there's a lot of employers out there that will say, listen, I don't really care what these people did, on the weekend when they weren't working, and it wasn't going to impact their job. As long as they show up for work and they're doing a good job, I don't care what they do on their free time. But then it gets complicated because we have to do random drug testing, or we do post-accident drug testing, and then someone comes up positive, and now what do we do? So I do think that this is something that employers are struggling with a lot, and rightfully so. And I don't think this issue is going away anytime soon. We are told that the science is just not there in terms of being able to determine whether or not, at what level an employee would be considered under the influence, or at what level you could tell if they had recently consumed the marijuana. So there's a couple of different points in employment that employers will conduct drug tests, and I think flexibility and discretion here varies depending on what type of test we're talking about, at what point in employment we're talking about it. So pre-employment, many employers include drug testing as part of a pre-employment inquiry. And what we have seen is that surveys show in states where recreational marijuana has been legal for a little bit longer than we've had it here, that employers are gradually moving away from either including marijuana in the pre-employment drug screen panel, or they're choosing to ignore a positive test result for marijuana to expand applicant pools and give folks the benefit of the doubt. I think this is something that a lot of employers have called me, and I can't say that they are all doing it, but they're interested in the concept of, is this something that I could do? What would be my risk? Am I then deemed to be on notice that this person could, harm others? I think the answer there is no, for exactly the reason that created this problem in the first place, which is that if someone tests positive, it could have been up to 30 days before since they actually consume the marijuana. And so it can be something that is, I think, reasonable for you to ignore or take a different approach in the pre-employment setting than you would in some of these other instances. So I think that's a place where employment lawyers would probably say, okay, if you want to be a little bit more lax or a little bit more flexible, that might be an appropriate place to do it. Reasonable suspicion testing is sort of the other end of that spectrum, right? So if you have reasonable belief, reasonable suspicion that someone is currently working under the influence of drugs, then you should send them for a drug test. And frankly, this is not a place where I think most employers should exercise caution or should exercise discretion and be flexible, because the very concept of this testing is that you think this person actually was under the influence at work. And I think that can create a lot of potential safety issues if you're in a safety sensitive environment, And that can potentially be deemed to have put you on notice that this person uses drugs at work and could potentially harm others. So this is sort of the opposite end of the spectrum in terms of where I think most folks would recommend you be flexible. Pre-employment being the area where I think it makes the most sense, reasonable suspicion being the area where it makes the least sense. A note about reasonable suspicion before we move on, which is that it really should be based on objective factors that are well documented. So there are organizations out there that will provide you and your supervisors with training and with checklists on what reasonable suspicion should look like in terms of physical appearance, in terms of behavior, and really help supervisors and managers know when to spot a situation where someone may be under the influence and how to properly document it. Because you certainly don't want someone being sent for a drug test because they're exhibiting an odd reaction, for example, to medication. That would be a problem. And you want to make sure that you're not singling people out or treating people in a disparate way when identifying them for reasonable suspicion drug tests. So make sure you're consistent, make sure your folks are well trained, but certainly would recommend that you continue this area of testing. With respect to random testing, many employers will conduct random testing. It's not required by the Act. And, you know, I think this is one of those things that different employers handle it differently. Again, I would just say make sure that you're ensuring uniform and non-discretionary or non-discriminatory testing practices to avoid some sort of claim that someone was singled out or treated unfairly. Random testing and post-accident, which we're going to talk about in a minute, are areas where I think employers also could potentially exercise some discretion with respect to a positive test result. So I think there are two inquiries here. One, do we send them for the test? And two, what do we do about a positive test? And with respect to random and post-accident, I think you can continue to send them for the test. The question then becomes whether or not there's a basis to exercise some sort of discretion and take action less than termination if someone tests positive in a random or a post-accident situation. Post-accident usually is something that employers will do either when there has been an injury or damage to property, a recordable injury, so not like a paper cut, for example, but an injury or there's been property damage, and employers will routinely conduct drug tests in that situation. And again, if there's no indication that the individual was under the influence or that this actually caused the accident, then potentially an employer may want to exercise some sort of discretion, like putting the person on a last chance agreement or something similar to that. Again, just make sure those policies and practices are uniformly enforced. Accommodation. So this is something that comes up a lot, actually. The Act itself does not require an employer to accommodate use of marijuana at work. So it's not required. And that is also true under the Medical Marijuana Act. So employers do not have a duty to accommodate use of medical marijuana. That came out of a case from 2012 and has been reaffirmed several times. So just because someone uses medical marijuana doesn't mean that you cannot take action based on reasonable suspicion that they were under the influence or a positive drug test. Actually, the Cassius case is very interesting. It was a post-accident situation. The employee was being prescribed medical marijuana for cancer treatment, so a very sympathetic plaintiff. And it went up to the court because he said that because there was no indication that he was under the influence and that that's what caused the accident. And he said, listen, the employer should accommodate me because I have this very serious medical condition. This is prescribed by my doctor, and it's just a positive drug test. Like, I didn't do anything wrong. There's no instance of misconduct here. And the court basically said, while we're sympathetic to your situation and to your position, the law itself, in that case, the Medical Marijuana Act, doesn't speak to employers. It talks about criminal enforcement and your rights against being prosecuted if you're a medical marijuana user. It doesn't have anything to do with the workplace. And the court said, so there's no duty to accommodate. Like I said, that case has been affirmed multiple times. Just one caveat here, under state unemployment law, if someone like Mr. Cassius tests positive and is terminated, and there's no other indication of misconduct or that they were under the influence at the time, under the Michigan Unemployment Insurance Agency's interpretation of the law, that is not disqualifying misconduct. So they may still be able to have benefits, unemployment benefits, even though the termination itself was lawful. There's a difference between whether or not a termination was unlawful and whether or not you have committed misconduct under the unemployment statute, which would prohibit you from collecting benefits. I will just say that this is one of those areas that varies by state. So to the extent you have operations in more than one state, check your local listings, check with your local lawyers, because this is really a hot topic nationally, and there's a lot of courts that are kind of going the other way. Connecticut and Delaware within the last year both have seen their Supreme Court say, well, we think there might be a duty to accommodate the use of medical marijuana. So again, in Michigan, it was based on the statutory language, so I don't see that changing, but it is something to be aware of if you're operating in multiple states. One more word about accommodations before we leave, and this actually ties nicely into the non-discrimination issue, which is that some employers will say, well, what if we want to accommodate? What if we want to accommodate medical marijuana? And I think that's fine. You know, again, I wouldn't recommend that you do so in a safety-sensitive job, but if this person works at a desk, or if you can move them into a non-safety sensitive position and you want to accommodate it, that would be fine. Just, you know, resist the urge to play doctor with respect to one person's medical marijuana card for a specific condition versus another, and trying to say which one you think has more merit. It really should be job related, consistent with business necessity, and specifically the issue of safety. Those are things that I think should be considered when deciding whether or not to accommodate use of medical marijuana. So non-discrimination, again, just because marijuana is now a legal substance doesn't mean that it is somehow protected or a special, afforded special status under the law. You can discriminate against someone because they use marijuana. That's exactly what the law says. However, it's important for employers to be careful to maintain a consistent rationale and to continue to treat people the same in similar circumstances. Otherwise, it could be used to argue that it's actually a pretext for discrimination. And so this cautionary tale is played out in this case, EEOC versus the Pines of Clarkston. This is a nursing home facility, long-term care facility, and the employee was terminated after testing positive for marijuana. She was actually prescribed medical marijuana for her epilepsy. She disclosed that to the employer, and the employer terminated her. She said that it was actually because of her epilepsy that she was terminated, not because of her marijuana use. And she said actually at the termination, when she disclosed that she was epileptic, that the employer said, oh, well, I don't think you can work here if you have epilepsy. And she used that as evidence that that's the reason she was terminated. And the employer had a little bit of a proof problem in this case, because the employer's reasons kept shifting a little bit. At one point, it was because it was a positive drug test. At another point, it was because she had not disclosed ahead of time that she was a medical marijuana user. And at another time, it was, oh, because there's also this belief that she may have sold drugs on the premises. So this reason kept kind of changing, and the court said, listen, you guys can't really get on the same page about why you terminated this person. And the employee, the former employee, now plaintiff, has a very clear recollection of the termination meeting. And we think it's up to a jury to decide whether or not this person was terminated because of their epilepsy, which would be potentially a violation of the Americans with Disabilities Act, or if there were actually legitimate non-discriminatory reasons. So this goes back really to just sort of employment basics 101, which is make sure that your employment actions are well documented, well considered, and everyone is on the same page with respect to why a specific action is being taken. Otherwise, it could look like it's a pretext for discrimination. The DrugFree Workplace Act, this comes up somewhat frequently with employers. It applies if you do business with the federal government, if you have grants or contracts of $5,000 or more, so not big money, and you have 25 or more employees, you would be subject to the DrugFree Workplace Act. Under that act, an employer has to certify certain aspects of its policies and practices that it maintains a drug-free workplace, right? Drug-free equals marijuana-free. So if you are subject to this act, it can provide you with a very clear reason to not be flexible on the issue of a positive drug test with respect to some of those issues we talked about earlier. So pre-employment, random, or post-accident, if you were inclined to exercise some discretion, this could potentially provide you with a reason not to do that. I will say the one caveat to this is I have never seen the Drug-Free Workplace Act be enforced or part of an audit or part of, a government contract review. And so this is not an area of law that is very litigious or risky. So while this can provide you with good cover if you wanted to, I think you should, if you're inclined to be flexible and you think you're subject to this act, you should definitely consult with your attorneys and see whether or not there's any way for you to sort of be flexible around the requirements of this act and how you can proceed in a lawful manner. And with that, I'm going to turn this over to Kevin. He's going to review a little bit of the facts on the ground with respect to what's happening with the ASC members.
Great, thanks, Ellen. If you could go to the next slide. Great, so ASC, as Lori had mentioned earlier, we're a membership organization based in Michigan. Our members are Michigan organizations, primarily in Southeast Michigan, but we have members throughout the state. And in November, when the law was passed, we surveyed our membership on a number of factors. First and foremost, their impression of the new act or the passed law, and then what impact that may have in their organization relative to their policies or their approach to drug testing in the workplace. ASC does support our members in terms of drug testing and pre-employment issues, so it was an important area for us to look at. Some of the results were surprising and some not so much. I think our survey showed that there is a fair amount of concern, or at least initially when the act was passed, there was some initial concern, or is some initial concern among our members. 71% were either very concerned or somewhat concerned about the new law and what impact it will have on those organizations. And I think largely that's a function of the fear of the unknown or the fear of unintended consequences of, now having more folks, having greater access to marijuana. And so for them, it was a question in terms of what does this mean for us organizationally? So what we looked at, and some of the questions that we asked related to how confident the organizations were about their existing policies. And for the most part, our organizations, 68% were either very confident or somewhat confident that their policies were equipped to handle the new law. as it was written. And I think to Ellen's point, in terms of what has been passed in the Act, there's still no requirement that the employers are required to permit the use of marijuana, medical or otherwise, in the organization. So I think for the most part, the current policies that employers have in place are deemed by at least the employers that we've spoken to be sufficient at this point. Ellen, next slide. If you could go to the next slide, Ellen. Oh, you've got it. Sorry. Back one. Didn't advance on mine as fast. So one of the questions we asked, given the recent changes in the law, is your organization considering any changing to its drug testing policies? Only 15%, or roughly about 27, 28 organizations indicated yes out of the 183 that they plan to do any or make any changes to their existing drug policy. And I think that says a lot about their sense of how their existing policies are going to be equipped to handle the new law. Where we saw some of the most changes, at least again, those small numbers at 15%, most would be looking at no longer testing for marijuana, or probably more importantly, looking at the reasonable suspicion criteria. But again, a very small minority of companies looking at making any changes to their current drug testing policy. Next slide, Ellen. Irrespective of their current policy, we asked also if the organizations were considering any changes to their workplace drug or substance abuse policies or practices. Practices, I think, here being the operative term. And again, most organizations, 49%, were not. I think the large number of unsures is probably telling. I think more, this was, when we conducted the survey, it was pretty early days. Organizations were kind of taking a wait and see approach to see if, what they learned about the new law through presentations like Ellen's here would require them to make any changes. But at least initially 49% said no, they weren't going to make any changes to their policies or practices. Next slide on. Most organizations said they will be communicating to employees regarding their the new law in terms of its impact on the workplace and specifically impact on the employees. Again, it's important to communicate to employees, given the new law, it's not, sort of a Wild West in terms of, their ability to use marijuana in the workplace. And so I think it's important, as Ellen stated earlier, to share communication with your employees regarding the new act. And 44% indicated that they were going to share some information with their employees. And again, that 40% who are unsure at this point, again, I think it's a lot of a wait and see in terms of what the new law will require of employers moving forward. Next slide, Ellen. Again, we asked in terms of specific policy language, does your organization have any written substance abuse policy? Most of our organizations do, in fact. I think our organizations, the median size organization, is probably the 150 to 250 employee size range. So in many cases, I think a large number of these employers are large employers. So they probably do have, by this point, a pretty strong substance abuse policy, and I think that will continue. And then again, the other question we asked, does your organization have a zero tolerance policy when it comes to drug use? Again, most of our organizations, 83%, have. And again, if you think back to the previous slides in terms of what changes that they are considering making as a result of this new law, a few of the folks that we surveyed, again, are making any real substantive changes in their policies. Next slide, Alan. We also asked our members what types of drug testing they currently conduct. And this really hasn't changed a whole lot from years that we have surveyed. Most of our organizations are doing pre-employment testing. Where we will likely see an increase and where we're expecting to see an increase probably is the reasonable suspicion We've heard a lot from members that are trying to educate their supervisors and managers on what is reasonable suspicion and how, again, as to Ellen's point, they can uniformly enforce that reasonable suspicion. The next most common type of testing was incident, obviously, which is certainly important in certain environments. Next slide, Ellen. I think that should do it. Again, just to give you a sense of who we've surveyed, again, a majority of our participants were from the Detroit metropolitan region. Again, as I'd mentioned before, our organizations are the small to medium sized employer, so probably in that range of about 150 to 250. Majority of the organizations were manufacturing, 63.9%, most for-profit, and just given the nature of our membership, many of them are automotive suppliers or of one shape or form or another. And that is it. So I think now we're going to turn it over to the Q&A.
Yes, thank you both. A lot of really good stuff here. We do have several questions for both of you. I'll start with the top one. This one's from Jana. Can you provide resources for training managers on the reasonable suspicion? This comes from your zone at the start. Can you provide resources for training managers on the reasonable suspicion? I believe that was when it came into the testing area.
I know we've shared some information with members on some guidelines in terms of stand-up or instructor-led training. I'm not 100% sure of some immediate resources, but that would be a good example of a hotline question through the Small Business Administration. I think that's probably something maybe, Lori, we can share with you.
Okay, that'd be great. Any thoughts on that, Ellen?
Yeah, I try to avoid recommending specific vendors, but there are a number of vendors out there that will provide this on-site training. And I think actually Kevin ASC was thinking of rolling out a program like this, so that may be something you could get that service as well. So I can't say that I have a specific recommendation, but there are a number of vendors out there that will provide this training for you and really recommend you pursue those.
Okay, next question. If there is a positive test at pre-employment and random testing, should or could there be a discussion with the person about use and or impairment at work? So if they've tested positive, pre-testing or random testing, should there be a discussion?
Yeah, so I definitely think you should always take some action with respect to a positive test. So it really, circumstances would determine what that action entails. So if it's pre-employment and you're going to hire this person anyway, it is probably worth a discussion saying you passed, we're still going to hire you. However, know that our policies are X, Y, and Z, and if you test positive in you could be terminated. If you want to exercise some discretion. With random, I need to have some conversation. And if the person is already employed, I really recommend that you document the conversation. And potentially, depending on how the conversation goes, it's a written lapse agreement, it's a counseling or referral to the EAP. Oh, Lori, we can't hear you.
Oh, sorry. Kevin, if there's anything to add. Both speakers, Ellen and Kevin, we're getting some bad feedback. So if you're not answering the question, would you mind muting? Tenny's having a hard time hearing the answers. So I just wondered if you had anything to add to that question, Kevin.
I don't, I'm sorry.
Okay. Let's go on to the next one, and then I'm going to mute myself. This one's from Michael. If testing for marijuana is inconclusive as to time used, how is testing for it in any circumstance of value if post-accident or reasonable suspicion? So if they test positive and it's inconclusive on when they used it, how is that used in an accident situation or during reasonable suspicion? Good question. Who wants to take a crack at that?
I'd be happy to start. It is a good question. I think there's a couple of things that are at play here. One, don't ignore your other senses, right? So if the person is acting under the influence or there's other indicia that the person may be under the influence, those should all be documented and taken into account in addition to the positive result, right? So it's just now one piece of information among many, no one of which is determinative. And that could work in the employee's favor or not, right? As a practical consideration, I think a lot of workers' comp insurance policies and many general liability or property coverage policies will require drug testing post-accident if there's property damage or if there's an injury, a workplace injury. And so make sure that you're checking those insurance policies because they may also have something to say here with respect to what action is taken and whether or not you were in compliance, because you certainly don't want a workers' comp claim denied because you didn't conduct appropriate testing as required under the insurance policy. So it's not determinative, but frankly, at work, many things are not determinative, and many folks, are faced with having to make a decision based on imperfect information, and you have to sort of take all of the evidence and make the best decision you can. The drug test being simply one of those pieces of information.
Thank you. This next question has to deal with at-will employment. I'm sure pretty much everyone's familiar with that. In respect to at-will employment, does that come into play in this realm? Can that be something you put in your handbook and it takes care of the issue?
Sure, I'll take that one as well. So I love and hate at-will because I think it creates a sense of security that may not otherwise be there. So at-will employment means basically you can be terminated for any reason or no reason so long as it's not illegal, right? So long as it's not illegal is sort of the exception that overcomes the rule in many situations. So as long as you are enforcing your policies consistently and in a non-discriminatory way based on good information, then yes, folks are at will, and we're in an at-will state, and use of marijuana is not protected. So you certainly can use your discretion under the at-will employment doctrine to take action. However, you also don't want to run afoul of one of the other statutes. So for example, if someone claims that they were terminated discriminatorily, just because marijuana is implicated, just like we saw in that EEOC case, doesn't mean the employer is automatically off the hook. If there's another protected characteristic at issue or there's a claim of discrimination or harassment, you would have to deal with that just like you would in any other instance of potential employee misconduct.
All right, and our last question, folks, if you have a question, please get it in right now as we wrap up here. This one comes from Linda. Linda says, I'm a landlord in Michigan. I currently prohibit smoking in my properties, including marijuana. Am I allowed to also prohibit possession and cultivation?
So full disclosure, I am not a property lawyer, so to the extent you're asking about this with respect to your tenants, I'm not the appropriate person to ask that question to. If you're talking about can you prohibit it based on your employees, so if there's grounds people or maintenance people, the answer is yes. You can prohibit possession, you can prohibit cultivation or use on your property by your employees. And I would say, again, this is not my area of expertise, but I do believe generally as a property owner, you could prohibit those things even as a landlord. But again, you'll want to check with your with a lawyer who practices specifically in that area.
Thank you. And Linda, if you'd like to follow up with me after this regarding that question, we could probably seek the answer to that from SBAM's provider for legal questions that we have. So, well, thank you, Kevin and Ellen. You've done a great job. I really appreciate the time that you took today to be with us. This will be recorded, and I will send out copies of the slides as well to all the attendees. And thanks again. If there's nothing else, I appreciate it all. Everybody stay warm on this very cold day. Thank you.
Thank you.